Good morning, everyone, and thank you very much, Louis, for your very kind introduction. I am talking about winding up petitions, which have become a bit of a rare breed in the courts since March 2020. It remains to be seen, really, if they are back with a vengeance, but I think they will certainly become more of a common sight again. The reason for their rarity was, of course, as you will all know, Schedule 10 of SIGA 2020, as was originally enacted. That has gone now. It will only apply to petitions issued pre-October 2021, of which there will be relatively few. So I'm not going to talk about it today. Let me just... What I will be talking about is what I've termed new Schedule 10, which conveniently has just replaced old Schedule 10 in its entirety. So in this talk, I will start with some key reflections and takeaways. I'll then get into the meat of new Schedule 10, in particular, the four what are just called conditions, which I think is much more straightforward than old Schedule 10. I will also briefly discuss how new Schedule 10 also modifies the insolvency rules, and finally touch on what I would suggest are some practical tips. So what are the key reflections from new Schedule 10? Well, I think it's fair to say that it aligns the process much more closely to the pre-March 2020 regime than the pandemic regime. And because I am perhaps overly fond of a bad sporting analogy, please forgive the following, but if the pre-pandemic era was like the 100-meter hurdles, there were some obstacles in the way and you might pull a hamstring. Generally, though, it was a relatively quick process. Old Schedule 10, the pandemic era, I think turned the whole process really into a 3,000-meter steeplechase. It was much longer, and now and again, you'd have to jump over a barrier and might fall into some water. It was also much harder, really, to predict the outcome. I think new Schedule 10 is more like the 400-meter hurdles. It's a bit longer, but it's pretty much the same race as before. Essentially, yes, we've got these three regimes. The new one is, I think, much more aligned to the original. The new regime, new Schedule 10, is presently due to end in March 2022. And as is made clear from the explanatory memorandum, it's expressly designed to create a tapering effect as the economy gets back on its feet, to, in particular, allow small businesses some more breathing room and to encourage negotiation between creditors and debtors. Now, predicting whether or not it does actually come to an end in March 2022, I think is probably a fool's game. I suspect, as ever, it will probably largely track the progress of the pandemic and the wider economy. Many are, I think, quite skeptical that it will actually end in March 2022. I'm not so sure. I suspect there will at least be some tweaks to it then, perhaps to the minimum debt level, but ultimately, really, we will see. Overall, my view is that new Schedule 10 is much more user-friendly to read and interpret. And as ever, there is really no substitute for reading it, and it is relatively short. My notes do contain a link to the legislation, and I think it can also be relatively easily found on Google. What it really does, and what I will discuss now in more detail and introduce, is introduce four conditions. So those are A, B, C, and D, which I think is actually also quite helpful naming nomenclature. And to continue really the bad analogy, I've also described each condition as a hurdle, which must be cleared. So the first condition, condition A, which is what I've termed the gateway hurdle, it is, I think, quite straightforward, this one. Your debt must be a liquidated debt that has fallen due. The second part is that the debt cannot be what is defined as an excluded debt, which broadly means commercial rent arrears or another sum due under relevant business tenancy, and that's also defined, which, and here's the kicker, is unpaid by reason of a financial effect of coronavirus. Now, that kicker is not in exactly the same format, but what I think it will continue to do is engage the same sorts of considerations and essentially the same test as what was called the coronavirus test from old Schedule 10. And because, like any barrister, I cannot resist referring to a case in which I appeared, and Louis, I'm afraid I'm perhaps not quite as modest as you may have hoped. But if you need to refresh your memory of that test, I would refer and recommend you the case of A and B, which the citation is there on the slide. But essentially, I would suspect the number of debts still about that would potentially satisfy that test, and which also satisfy the excluded debt part, will be vanishingly few. So if in doubt, consult the legislation or seek advice, but I suspect most debts will not be considered. Condition B is what I've called the procedural hurdle. And again, I think this is relatively straightforward. Essentially, before presenting a petition, it requires delivery of a notice to the debtor company that must comply with certain formalities. For example, providing details of the debt and other such things, and those are all specified in the Act. But crucially, it must also contain a statement in the form which I've put on the slide there. So if no proposal to the creditor's satisfaction is made, etc. So essentially, it's a warning shot. It gives the debtor 21 days to make proposals which are to the satisfaction of the creditor, failing which there is a clear warning that a winding up petition will be presented. There are also, I think, fairly typical usual requirements as to delivery of the notice, i.e. it must be delivered to the debtor company's registered office, or if that is not known or it's not practical, to deliver it there to the last known place of business, a company secretary, director, or manager. So all reasonably straightforward, I think. Condition C, this is, I've termed the payment proposals hurdle. Now, this is the shortest condition, and I think it's created by far the most excitement amongst commentators. But if you are acting for a creditor, really, this condition should hold no fear for you. The condition itself is short, so I can read it and will read it in full. It says, condition C is that at the end of the period of 21 days, beginning with the day on which condition B was met, the company has not made a proposal for the payment of the debt, that is, to the creditor's satisfaction. And the open issue, and what I think generated a lot of interest, is how will the phrase "to the creditor's satisfaction" be construed? Because on the face of it, it appears to give creditors an unfettered discretion. Well, I'm sure, and many more learned commentators than I am are also sure that it won't. And interestingly, well, I'm not sure, maybe putting a bit highly, but there was actually a House of Lords committee debate on hearing on new Schedule 10 this week. And having read the transcript of Hansard, so you don't have to, you can see that the presenting minister expressly referred to this condition as allowing the court to use its inherent discretion to refuse to make winding up orders. Well, I'm sure the courts will be a little more rigorous in their analysis than simply referring to inherent discretion. What I suspect, and what others I think have referred to as well, is that it may be that parallels could be drawn from the concept of offers of reasonable security in the context of bankruptcy petitions. Now, of course, an offer of security is different from payment proposals, so it's not exactly the same. But I'm reasonably sure that useful parallels could be drawn. And in summary of those, offers should be present and capable of acceptance. They should not merely be the possibility of a future offer. The court will look at whether refusal of an offer represents a course of action outside what a reasonable creditor might take. And any refusal should be the result of proper consideration. But, and I think crucially, creditors do not need to negotiate. They do not need to be patient or generous. And they are, I think, of course, entitled to take account of their own interests. Now, there's far more detail on these sorts of considerations, which I put in my handout, and I've referred on the slide there to quite a recent Court of Appeal authority, which really affirms those principles. But the reason I say that this condition should hold no fear for creditors is because of what I put at the last bullet point of my slide. And that's essentially that English courts, and quite rightly in my view, do not like to get too involved in what can be described as commercial considerations. So if, and there's a key there, but if you can properly evidence that an offer has been considered but refused for reasons which are commercial and which, at least on the face of it, appear reasonable, then I suspect that the court is very unlikely to go too far behind that. So I would suggest that the more reasonable payment proposals might seem, the more important it is to explain why they are not in fact to the creditor's satisfaction. So evidence is key. But beyond that, I don't think there is any particular magic in this. It simply gives the courts a way of ensuring that creditors are not behaving entirely unreasonably, but properly justified. I suspect it is not going to be an insurmountable hurdle at all. So the final hurdle is what's called the debt threshold hurdle, or what I've called the debt threshold hurdle. It's actually called condition D. And again, I think this is relatively straightforward. It actually may be the condition that has the most impact in practice, because it has the effect of filtering out most debts below £10,000. And I say most debts because if you are one petitioner or one creditor, your debts can be less than £10,000 if you can club together with other creditors to present a petition, provided the total debt to creditors owed on the petition exceeds £10,000. But as I've hinted here, this could create some complexities, because at least in my reading of the legislation, and I think this is right, if a crafty debtor were to make payment proposals which were to the satisfaction of one creditor, then the other creditor, who might not even had any proposals presented to it, cannot present a petition, because all of the conditions, A, B, C, and D, must be satisfied for all of the creditors if you need multiple creditors to get over the £10,000 debt threshold. And that's, of course, relatively logical, because the satisfied creditor isn't going to be interested in a petition if they have had payment proposals made which are to their satisfaction. But essentially, they cannot be dragged along in an essentially neutral way if they cannot say that the proposals made to them are not to their satisfaction. So are there any ways of circumventing any of the conditions? Well, yes. Unlike in an actual hurdle race, you can swerve a couple of the hurdles by applying to the court to apply to disapply conditions B or C. So that's the 21-day notice requirement and the payment proposals hurdle, or you can apply to shorten the 21-day notice period or period. Now, it'll probably be quite a rare situation where you would do so. Examples may be where the company has essentially gone AWOL or very unresponsive for a long time, or perhaps there are concerns regarding asset dissipation and there's a desire to get a liquidator in there as quickly as possible. So it is possible, but I think it will be relatively rare circumstances where it's justified, and it only applies to conditions B or C. So condition D, the debt threshold, cannot be disapplied, nor can condition A. So that's the nature of the debt itself. So again, no prospect of disapplying anything to do with the commercial rent arrears. There is, I think it's also important to point out, and this is an entirely practical point, but what new Schedule 10 also does is effectively insert into Rule 7.5 of the Insolvency Rules 2016, that as well as the usual things that petitions must contain, petitions must also contain a statement that conditions A to D are met and that either no proposals for payments have been made, and if that's the case, that's quite easy to state and assert, or if proposals have been made, that they are not to the creditor's satisfaction. And crucially, it must say why they are not to the creditor's satisfaction. So the word why there is key. And again, it indicates that you can't just say, these proposals are not to my satisfaction. I don't see at all why it couldn't be a relatively brief explanation as to why. And if needed, it could refer to a supporting witness statement giving more detail. But I think it is important to clearly comply with that condition and do so in a way that pays more than just lip service to the requirement. Some sort of explanation is really desirable to satisfy the court. The next thing which I will talk about is the practical tips. So these are essentially what I would suggest is the things to consider now we are more back in the old world. So yes, the last area that I want to touch on is what I would suggest are some practical tips now we are in this new world. And I can't really say that any of this is much more than informed speculation, because I don't yet have any experience of how these petitions will quite work in practice. If anyone does, I'd be very interested to hear it, but I suspect that most are still filtering through to hearing dates. So what I've suggested is refamiliarizing yourself with the usual formalities. There are now more hurdles to surmount, so I suggest that you don't want to trip up on what I describe as one of the old hurdles. So certain courts, perhaps Leeds or Manchester, have certain different practices regarding perhaps service of petitions, those sorts of things. So do refamiliarize yourself with that if you're in any doubt. Practical terms, I think that debtors will have more lines of challenge now, and in practice, I'm not sure how it will work if in the winding up list, a creditor says that the payment proposals are not to their satisfaction, and the debtor turns up to say that that is completely unreasonable for all of these sorts of reasons. Winding up lists, as I'm sure you will know, were fast moving under the old system. There will, I think, certainly probably be a backlog which does now start to filter through. And so there could be very busy lists. And it's unlikely that the court will have much more time to take a view on this. There may well be clear and obvious cases where payment proposals on the face of it can be clearly seen as unsatisfactory. But it may be that this is something that would need to be listed to be considered in a separate hearing in more marginal cases. So that is why I've suggested essentially on this slide having a fallback position regarding potential directions for either adjournment or a separate hearing to consider payment proposals. Beyond that, I think we'll all be learning together. The key thing, though, is that to present a petition under the new regime, you must satisfy each of conditions A, B, C, or D. You must clear each hurdle, or you can apply to the court to disapply conditions B or C. The legislation, as I've suggested, there's a link in my handout. It is quite straightforward and easy to read. I think it's much more user-friendly than the old Schedule 10. But really, beyond that, we're in a new world. It's more like the old one. We'll see when it ends, but I think it will at least be interesting. That really concludes my talk. I'm conscious that I'm probably well ahead of schedule, but I don't think there's much more to say, as it is kind of a fairly straightforward regime. But if you have any questions, do feel free to put them in the chat box. I can see that there are some there, so I'll have a look at those now. But if there's anything else you want to ask which I haven't covered, I've put my email address there. And do please feel free to get in touch with me directly. So thank you all very much for attending. I hope that was of some use. And I will now just look at the questions. There's a question there from Paul Lucas. Do you consider that a written notice can be given at the same time as a statutory demand? Yes, I mean, essentially, I can't see any reason why not. The old world where petitions could not be founded off the back of a statutory demand, that's gone. So statutory demands are back in place, but essentially, it's written notice requirement is a new thing on top of that, which you have to comply with. No reason why you can do both, as long as you comply with the time limits at both, and as long as essentially both tick all the same boxes. I think it's worth making everything pretty clear as to what it is, so there's not any ambiguity, and the debtor can't point it to hearing and say, well, it wasn't clear that this was a notice, or it wasn't clear that this was a demand. But beyond that, I can't see any reason why not. Neil Russell has asked, rumours of the government introducing the arbitration scheme for landlord-tenant commercial rent disputes, what effect will this have on the ability of a creditor to engage in new Schedule 10 of SEGA in the short term? I think that is expressly acknowledged in the explanatory notes and memorandum, and that's the reason why you've got this definition of an excluded debt. And if you do have an excluded debt, so commercial rent arrears, you essentially can't present a winding up petition because you can't satisfy condition A. So what they've done is continue to hive off and treat separately these commercial rent arrears. And I think the intention is, as I understand it, to continue to do so until they've got their act together and actually introduce this arbitration scheme that they've been mooting since the I think early summer, when the forfeiture restrictions continue to be extended, because they're also due to end in March 2022. I think the hope is that by March 2022 there will be some sort of arbitration scheme, and at that point I suspect that there perhaps will continue to be a definition of excluded debt, whereby you can't present a winding up petition and everything that falls into that bucket has to go off to that arbitration scheme. That would seem to align with everything that's happened to date, but I don't think there's any proposals yet, so it's not quite clear, so we'll have to see on that one. Gaynor was asked, does the notice replace the statutory demand route, or must we send the notice regardless? You must send the notice regardless unless you apply to the courts to disapply that provision, which, as I've suggested, would be probably an unusual situation to do. It hasn't replaced it necessarily. It's just an extra layer on top. You can still present a statutory demand, but clearly there are some situations where creditors don't actually present statutory demands and still present winding up petitions if you can prove insolvency effectively. So it's a new thing that you have to do. As I say, it's the warning shot, which gives the debtor a set number of days. Darren has asked, is there any point in serving statutory demand? Will a letter for action and the notice not be a better and quicker way to proceed? I think you're quite possibly right, Darren. I think it's often been the view of some practitioners that actually a statutory demand is not really necessary as long as you can prove insolvency for the purpose of the petition. It's ultimately that's a practical matter. As again, I think the takeaway really is you have to comply with the notice requirement. You have to serve that, and that has to tick all the boxes. The statutory demand is perhaps belt and braces to do that at the same time as well, but it's not strictly necessary. David has just asked, and sorry, I'm reading these. I'm sure you're reading them as well, but just for my benefit, could/can only proposal for payment in full be considered reasonable? So the court only considers the timescale, not the amount. I think, again, David, it's probably a commercial question. I can see what you're getting at here in terms of, would it ever be reasonable to, or would it ever be considered unreasonable to refuse an offer to pay less, essentially? Again, I suspect you're probably right in that it's always going to be unattractive for a creditor to take a haircut on a debt. That said, I think if potentially there were discounts and those discounts were reflective of something relevant to the dispute between the parties, or something along those lines, say an element of the debt is contended to be disputed and the payment proposals put forward for the undisputed amount in full but timescale dependent, then perhaps that's right. I think you're right that timescale will be the most relevant factor in many cases, because I think ultimately, if it's a petition debt, it's properly a petition debt, it should be undisputed. And so the full amount should be payable and accepted as being payable. It's just a question of when it can be paid. And I think, again, that aligns with the statutory purpose, which is to give companies which are having cash flow difficulties breathing time. It's not to write off debt or anything like that, but to give them more breathing time. So I think most things will come down to time. Dan Ellsworth just asked, would you suggest addressing that conditions A to D have been met in the petition itself or the verification statement, or both? Could these not be dealt with in your submissions? There's the requirements of the inserted into the Insolvency Rules 2016 by new Schedule 10 that the petition itself must state that conditions A to D have been met. If they've been disapplied for any reason, you could say that, but in most cases you have to say that they have been met on the face of the petition, and that is, I think, something that the court will at least look to. I don't understand, or as I understand it, I don't think they'll check whether or not you have in substance complied with the conditions, but they will look on the petition to see that you've at least said that you've complied with the conditions. So it is something you have to look at on the face of the petition. It doesn't say whether or not the verification statement also needs to address that. Again, best practice, and in terms of being dealt with in submissions, I'm sure we will in submissions refer to them having been met, but I think, again, it's a mandatory requirement to put it on the petition, so best to do there. I've got some further questions on the Q&A, so let me just turn to those. I think I've still got a few minutes. I'll just take these in reverse order for me, because the last one looks, the first one chronologically appears a bit more substantive. So Man's asked, will the court apply a subjective or objective test or a rejection of reasonable proposals for settlement? It's a good question, and I think the answer is we don't quite know. It's far more likely, in my view, to be an objective test. So again, it's in the context of a rejection of an offer for security in bankruptcy petitions. It looks at what the reasonable creditor would do, or essentially has what the creditor's done fall outside the scope of what a reasonable creditor would do. So I think it's far more likely to be an objective test, and but obviously that objective test will have an eye to the creditor's individual commercial circumstances. Charlotte's asked, how would you serve the Schedule 10 notice? Again, I think it's I'd have to check the exact language in the in new Schedule 10. As I understand it, it's simply posting it to the company's registered office, or if that's not practical, there are other addresses, is what's suggested or what's required of that. There doesn't seem to be any service requirements as to process server or anything like that. Again, it may be advisable to do so, especially if there's going to be any dispute or debate about that kind of thing. And it may be that courts do develop their own practice, for example, leads about wanting that kind of notice to be served by process server. So yes, I think as before, it's a case of posting it, but it may, as before, be worth making sure that you've at least got signed for delivery or can evidence service properly. And I think this is the last question I've got now. It's two parts by the looks of it. Understanding is that EU regulations no longer apply. Is Part N of the winding up petition form still relevant when a proceeding is considered to be common or established? Is this still relevant? Yes, I think it is still relevant as far as I'm aware. This is, again, it's new Schedule 10 is an overlay of requirements as to what petitions need to require an address, and because petitions do need to address COMI, unfortunately, because it's another slight complication. But yes, it still needs to say that. The next question is whether or not the petition needs to satisfy or Part L of the winding petition. Understanding is there is no longer a requirement to satisfy the COVID test. However, this section is still in the precedent winding up petition form on the government website. I think that's probably an error, I suspect, as there isn't a COVID test for petitions presented on or after the 1st of October 2021, unless you are potentially in the very rare circumstance of being an excluded debt where you're saying it's not COVID-related reasons for unpayment. So I can't see why that would need to be satisfied. It's Schedule 10 has essentially been replaced in its entirety, and the requirements are as stated there. So I probably want to double check that, but I don't see that you need to really address the COVID test in substance. And just the final question, I think, from Emma is where is the petition would you make reference to compliance with Schedule 10? Will this not go in the statement accompanying it? Again, my reading of the legislation is that the petition itself needs to contain a statement regarding compliance with Schedule 10. So I think, again, it's just on the face of the petition, and petitions do seem to be getting or have become ever longer in terms of what they need to say. So I would suggest, if it's all possible, and I'm sure it is possible, to put it in the face of the petition, and maybe, again, belt and braces, put it in the statement accompanying it as well. But certainly my reading is that it should go on the face of the petition. Sorry, I'm just reading this another question that's just come through. Can you send a notice under Schedule 10 and also instruct enforcement agents at the same time, and then proceed with winding up petition if the enforcement is unsuccessful? So I'm not entirely sure what the question is there. I mean, in terms of, I think to present the winding up petition, clearly you must send the notice under Schedule 10, give the debtor 21 days to make proposals. If there are proposals to their satisfaction, you can then present. In terms of instructing enforcement agents at the same time, it depends what you're trying to enforce there. I think if it's that's probably a separate process, to be honest. And I think it's possibly misunderstood, but I think really it's no reason in principle why not, but certainly for the winding up petition itself, it's the key is complying with the notice requirements. I think that is all the questions that we've had. I'm just checking across the chat and the Q&A. So I think that really concludes my talk. But as I say, if anyone does have any more questions, you do have my email address. If there's anything I was unclear on or didn't answer, or that occurs to you after, please do feel free to get in touch.